Welcome to our comprehensive legal guide on Texas intern rights in 2026. Today, we answer a critical question. When are unpaid internships legal in the Lone Star State? We will walk through the Federal Fair Labor Standards Act, the seven-factor primary beneficiary test, how the Fifth Circuit applies it in Texas, and what the Texas Labor Code and Texas Workforce Commission say about unpaid internships. This presentation is for educational purposes only and does not constitute legal advice. The foundation of all unpaid internship law is the Fair Labor Standards Act, or FLSA. Under the FLSA, any individual employed by an employer must receive minimum wage and overtime pay. The key question is whether an intern qualifies as an employee. The landmark case Walling versus Portland Terminal Company from 1947 established that trainees receiving hands-on training without displacing paid workers are not employees under the FLSA. Today, the U.S. Department of Labor's Fact Sheet number 71 provides detailed guidance. It explains that for-profit employers must pay employees, but interns may not be considered employees if the primary beneficiary test is met. The Fifth Circuit, which covers Texas, applies this same primary beneficiary analysis. Here is something many people find surprising. Texas has no standalone unpaid internship statute. Unlike some states that have passed specific laws, Texas relies entirely on the federal FLSA framework to govern internship classification. Texas is an at-will employment state. The Texas Labor Code Chapter 62 covers minimum wage, but it mirrors the federal rate of $7.25 per hour. The Texas Workforce Commission, or TWC, enforces state wage claims, but applies the federal primary beneficiary test. The Texas Payday Law, found in Labor Code Section 61, covers wage payment timing, not intern classification. In the Fifth Circuit, which covers all Texas federal courts, the Glatt versus Fox Searchlight case from the Second Circuit has been adopted as binding precedent. This means the same seven-factor balancing test applies nationwide. Factor 1 examines the extent to which the internship provides training similar to an educational environment. The more an internship provides clinical, hands-on training comparable to a classroom experience, the more likely the intern is the primary beneficiary. If the intern rotates through departments, receives structured mentorship, gets regular feedback sessions, and has clearly defined learning objectives, these are all strong signals of a legitimate unpaid internship. On the other hand, if there is no training plan, if the intern does repetitive busy work, if no supervisor is designated, and there is no skill development path, the intern likely should be classified as an employee. The educational element is critical to making unpaid internships legal. Factor 2 looks at the connection between the internship and the intern's formal education program. When an intern receives academic credit from a university for their internship, this is a powerful indicator that the intern is the primary beneficiary. Faculty oversight, formal learning objectives, and integration with classroom coursework all support unpaid status. The internship should feel like a natural extension of the student's education, with projects and evaluations tied to their academic program. But if the internship is completely unrelated to the intern's field of study and there is no faculty involvement, it leans toward employee classification. Texas universities often support these programs through career and technical education frameworks. Factor 3 addresses whether the internship accommodates the intern's academic commitments. The schedule should work around the student's classes, exams, and coursework, not compete with them. Good practices include offering part-time hours during the school term, not requiring work during exam week, aligning breaks with the semester calendar, and providing flexible scheduling. These all signal that the intern's education is the priority. But if an intern is required to miss classes or exams for work, that strongly suggests employee status. Texas also has child labor restrictions under the Texas Labor Code Chapter 51, which limits work hours for minors during school weeks. The stricter law always applies. Factor 4 examines the duration of the internship. It should be limited to the period in which the intern receives beneficial learning. Once the intern has acquired the intended skills, the program should end. Fixed duration programs of one semester or summer support unpaid intern classification. Indefinite or rolling renewals without new learning objectives suggest employee status. The Department of Labor guidance states that the duration should correspond to the academic term or learning period. If there is no end date specified, if it has rolling renewal cycles, or if the intern performs ongoing routine tasks, these all point toward employee classification. Factor 5 is the most commonly violated factor. Displacement. The intern's work must complement, not replace, the work of paid employees. If interns perform work that would otherwise require hiring additional employees, they must be paid under the FLSA. Working alongside and under close supervision of existing staff supports unpaid classification. But performing routine clerical, administrative, or operational tasks suggests employee status. The Glatt versus Fox Searchlight case from 2015 is the key displacement case. When the employer is the primary beneficiary, the intern is an employee, not a trainee. Factor 6 covers the expectation of compensation. Both parties must have a clear, mutual understanding that no wages are expected. A signed written agreement stating the unpaid nature of the internship is essential. Any promise of future compensation, stipend, or benefits undermines unpaid status. If a stipend or wage is provided, if future pay is promised, or if benefits are offered, these are all risk factors that point toward employee classification. Remember, the Texas minimum wage of $7.25 per hour applies if the intern is classified as an employee. Factor 7 addresses the expectation of a paid job after the internship. Both parties must understand that the internship does not entitle the intern to paid employment afterward. The internship must not function as a de facto probationary period or trial period for employment. Protective measures include a written disclaimer stating no job offer is implied, avoiding hiring promises, stating the temporary nature in writing, and setting a clear end date. If a probation period is implied, a guaranteed interview is offered, or a promotion path is discussed, the intern may be seen as an employee in paid training. The key case shaping Texas unpaid internship rules is Glatt versus Fox Searchlight Pictures. In 2015, the Second Circuit established the 7-factor primary beneficiary test now used nationwide. Unpaid interns on the film Black Swan performed tasks equivalent to paid production assistants, leading the court to create the balancing test. The Fifth Circuit, which covers all Texas federal courts, has adopted this same primary beneficiary test for FLSA intern classification. Texas federal district courts follow binding Fifth Circuit precedent, applying the economic reality analysis. Each case is fact-specific, and no single factor is dispositive. Texas state remedies include the minimum wage of $7.25 per hour, Labor Code Chapter 62 wage claims, and enforcement by both the TWC and the DOL Wage and Hour Division. If you believe an unpaid internship violates the law, there are multiple places to file a complaint. The U.S. Department of Labor Wage and Hour Division investigates federal FLSA violations. Call 1-8664-US-WAGE or visit dol.gov/HHD. They can recover back wages plus liquidated damages for up to 2 years or 3 years for willful violations. The Texas Workforce Commission handles state wage claims. Call 800-8329-243 or visit twc.texas.gov. Under FLSA Section 216B, interns also have a private right of action to sue in federal court. Penalties for misclassification include back pay, double liquidated damages, attorney's fees, and DOL civil penalties. Let us summarize the key takeaways for Texas unpaid internships. First, the federal FLSA 7-factor test controls because Texas has no separate unpaid intern classification statute. Second, the more educational the experience, the stronger the case for unpaid status. Structured mentorship, academic credit, and a fixed duration are essential protective measures. Third, when in doubt, pay at least the $7.25 minimum wage. The cost of misclassification is far greater. It includes back pay, double liquidated damages, attorney's fees, and potential DOL civil penalties. Always consult with legal counsel before implementing an unpaid internship program.